Hello and welcome back. This is Roger Royce, host of the 10,000 Startups podcast. And this week we are talking with Zachary Prince about governmental contracts. Zach Prince's practice covers all areas of government contract law on a wide range of issues. That's federal and state regulations, statutes, bid protests, it's etc. He's regularly also engaged to support acquisitions and financings on the due diligence side for companies that are involved in government contracting. And finally, he also is experienced in litigating government contract disputes in courts and with administrative bodies. And it seems to me that there are a lot of companies out there, including startup companies or companies that might do business with government contractors, who really probably could use a little bit of knowledge in this area. I know I certainly could. And I think we're probably going to be surprised at just how much of its own entity or its own world this government contracting is. So thanks for being here, Zach. And let me just kick it off with kind of the big question, which is why is it that this is an area of law by itself? To start with, what's so different about government contracts from just contracting with anybody else?
So the why is a good question that would take a lot of time to talk about, congressional interests that have popped up over the years and various executive orders. But in a nutshell, the mechanics, the reason that it's so different, there are a lot of rules that just don't have equivalents, and that's because of the way that government contracts requirements have come into place, and a lot of that comes through special interests that lobby Congress in certain directions in certain administrations, and then they become part of the rules, and then they evolve in certain ways, and then new rules come on, and every couple of years there's a push to simplify the requirements, but it only gets so far because a lot of the requirements are statutory, and Congress doesn't do very much these days. So we're left with this landscape where you've got a stack of regulations that are, per agency, a couple inches thick. And when you violate them, unlike in the commercial sector where a violation of a contractual requirement would just be a breach, material, maybe, maybe not. Here it could be a False Claims Act violation, which typically that's a civil penalty, but those are huge penalties. I mean, look at Booz Allen Hamilton. Last year, they paid $367 million, I think it was, to the Justice Department because of a allegation of an accounting issue coming on a government contract. I mean, there are really big penalties in this space that people don't always follow along carefully enough with.
So yeah, let's pause on that for a second. So False Claims Act at a high level, I think what I'm hearing you say is that if there is something that in just the normal civil, like maybe be a breach of a representation among private parties contracting, and maybe there's a claim for damages. I think what you're saying with government contracts, not only on top of that, there's going to be penalties, which are way higher than the damages. Is that right?
Yeah, there are treble damages by statute and statutory penalties of up to, I think it's now $30,000 per violation, which the government tends to take the view that if you've got a material issue in a contract that is a False Claims Act violation, every invoice you submitted is a violation of the statute. So those could add up really fast.
Yeah, how about criminal penalties? Is that a possibility in this area as well?
It happens. It's rarer. It's harder to demonstrate scienter. It's just going to be challenging to show that there's a criminal mind state. But the government doesn't always have to go there because they've got these great civil remedies available.
Okay. Well, when we talk about government, we talk about regulatory agencies. So who is it that's really prominent in the space? When we talk about government contracts, we're probably talking about some agency, aren't we?
Yeah, we're talking about a contract at some tier. It doesn't necessarily mean directly with the government, but where you're in the supply chain with the government ultimately sitting at the top. So sometimes that's actually challenging for a company to determine whether it is really a government contractor because they might just take the view, we're just a vendor to Northrop Grumman. We sell them our commercial software. They've got a license to the same SaaS product that everybody else pays for. Whereas Northrop might take the view, actually, you're a government contractor because we're using your product, we're using your software to service the government. it gets tricky. There's a lot of nuance there, but at the basic level, it means you're selling somewhere in the chain with the government sitting at the top.
Okay, well, let's say that's the case. So we're in the chain. We're selling to the government or somebody that is. What I mean, what do we have to think about? How is that going to affect the contract? Is it going to? I understand the false claim stuff, but is it going to require there be certain provisions in the contract? Is it going to force us into, I guess, stuff that we can't contract out of? I mean, what's the significance of that?
Yeah, there's a lot you're not going to be able to contract out of. It can get a little contentious, and for smaller dollar subcontracts in particular, it's not worth fighting about what goes in and what doesn't. You're just going to spend more on legal fees than you are going to save potentially in a compliance burden. So what the really sophisticated higher tier contractors, Lockheed, Boeing, et cetera, do is they have standard flow down provisions. So the government contract clauses will say this must be included in any subcontract over value X, Y, or Z, right? And it'll have other triggering criteria. In the standard terms, you'll have the flow down to your subs. You'll say this applies if, and then you'll list the triggering criteria. And then you'll have something at the top that just says this is self-deleting if inapplicable. That way, you don't have to really get in a dispute with your sub of whether it applies or not. Mostly, those are compliance obligations that down the road, if your customer, as the government, turns around to you and says, hey, why isn't your sub complying? You might have to have the fight then. You'll say, well, we flowed it down. And the sub will say, well, it didn't apply to us. It could get messy, but it's just easier to just accept standard flow down provisions, have them say something like self-deleting, have a basic disagreement about whether they are in fact deleted, and let it go.
Yeah. Can you give me an example of a provision like that? I mean, I'm thinking maybe there's a climate, requirement or DEI or some ESG. Is it something like that that might be included?
Well, we're definitely not going to see any of those for the next 4 years, but
Ah,
there was a greenhouse gas rule that has been in the works the past couple of years. I think that's pretty much DOA at this point. But more commonly, you'll see things like cybersecurity provisions. Those are really hot topics right now. And the government does not know when they apply because they apply to certain categories of data that the government employees have a really hard time classifying appropriately. But they are mandatory. So you'll say you have to comply with this cybersecurity standard for these types of systems, and then you'll let it play out, whether you think you actually have those systems.
I see.
That, yeah.
And then you're going to have to just go read the regulations to know whether you're in compliance with the contract then, I think is what I'm hearing.
You really ought to. I do counsel a lot of smaller businesses, particularly startups in the tech space that have accepted government contracts because their salespeople just don't really read what they're accepting. And then once they start getting in trouble or they get a general counsel or somebody starts reading it, then they turn to me and say, wait, what did we sign up to? And what does this actually require? That's obviously not the best way to go.
Yeah. Okay. And some of the agencies, I think you mentioned one or two of them, but uh, FAA comes to mind. Other agencies that are, we're going to see a lot of activity.
Yeah, I mean, Defense Department's the biggest spender just by volume. NASA is certainly big in this space. The civilian agencies, Homeland Security, General Services Administration or GSA, the Veterans Affairs, depending on what type of business you are, they spend quite a lot of money. Uh, Pretty much every branch of the federal government, particularly executive, spends a lot, something like 700 to 800 billion a year in contracts.
Okay. Well, let's shift gears a little bit, because that seems to me to be pretty straightforward. If you're negotiating a contract with somebody, and it's a government contract, we know that there's a set of rules and we're subject to those rules. But let's suppose we're an investor in a company that's a contractor, or maybe we're doing an acquisition of a company that's a contractor. I believe you said that part of what you do is the due diligence function and making sure the company is in compliance with its rules. Can you talk a little bit about how the rules come up in that context.
Sure. So I mean, they have an impact on every stage of a transaction from the beginning, assessment of the business's value, entering an LOI, the way you structure the LOI, letter of intent, uh, the structure of the acquisition, and any post-closing business and compliance assessments. That all has to consider the fact that government contracts are a different beast. I've seen more than once you go into a company's reported revenues that a investor is looking at when they're thinking about what they're going to pay, and they include essentially the cancelable contracts. Government contracts are always terminable at the convenience of the government, at the sole convenience of the government. The case law is really pretty clear on that. You almost never get those overturned. It's convenience of the government is broad. And even if you don't have a termination for convenience provision, and you always do, you also, they're almost always structured, these contracts, as one base year plus 4 option years. So if you book the revenue or you're purporting to have revenue guaranteed for certain periods, it isn't really, because the government can terminate, or the government can not exercise an option. And a savvy investor knows that. And they go into this with eyes wide open, and they get, this is the reason we think that notwithstanding the fact the government can walk away, this is still a viable business and they will receive this revenue. But if you're not thinking about it really with a clear understanding of the market, you're not going to do a thorough assessment of the business.
Yeah, good point. And if you think about it, I mean, the federal government is so huge and they spend so much money. I got to believe they probably impact a lot more businesses than you might think at first, right?
Yeah, I think that's absolutely right. And these days, at least half of my client base is non-traditional government contractors. They're tech companies that are trying to start selling to the government the same way they sell to the commercial space, because they see there's a lot of value there. But there's also a lot of risk. So they just have to proceed cautiously.
Yeah. Okay. So you started to talk a little bit about this, about what some of the issues that come up. You mentioned one, which is cybersecurity. Um, what are other hot topics or issues or negotiated stuff, or traps, I guess would be a better word for people entering the space have to think about?
So IP is a big issue, and is always a big issue. And the government contract space, IP rights are a little different than they are generally in commercial world. For the most part, the government acquires a license in IP rather than the IP itself, or I suppose it depends how you broadly you frame IP. But the government doesn't own your underlying intellectual property when, even if you've developed it in a government contract. They own a license, and it might be an extremely broad license depending on how it's structured. And businesses are not always very careful when they're developing IP using government funds to account for the development costs and be able to prove that out later. What was developed when, by whom? The government has a presumption that if something was that was delivered in a government contract, then that is information pertaining to intellectual property that the government paid for its development, and you have to prove later that it wasn't, hopefully through good records.
And this is not something you contract around. This is just the law. Is that right?
No, you can contract around it,
Okay.
especially with Defense Department. So they do have a lot of latitude to have specially negotiated license rights in particular. Patents are different. Patents are by statute under the Bayh-Dole Act. It goes back quite a bit, where if there is what's called a subject invention under a government contract or grant or cooperative agreement, the government typically would obtain ownership of the patent. They can opt for you to retain title. It gets a little nuanced, but for everything else outside of patents, it can be negotiated. It often isn't, because companies don't approach it with a full understanding of how this works.
Well, that raises the question: how would you know? let's suppose you're entering into a contract with a company that's subject to these restrictions because they're a government contractor, and all of a sudden you're subject to them. Um, what is there? I mean, like I say, how do you know? I mean, do you just ask, or do you do your diligence? Do you have contractual provisions, or is it their obligation to inform you?
So if you're lower down in the chain and you're contracting with somebody higher up, somebody with who has a contract directly with the government, your rights between you and them are purely contractual. Right? So if they screw up, they don't put appropriate IP provisions in there, they might be between a rock and a hard place. But that doesn't impact you, other than giving you quite a bit of leverage if it comes down to it later. And they realize that, oh, crud, we were supposed to deliver this to the government without restrictions. And we've contracted for a very limited license that now we have to figure something out.
I see. So it's their problem. I get it. Okay. Yeah, I've actually had that happen once, fairly recently, almost that exact set of facts. And it was a little bit it's a little scary because it's a little unknown. It's like, well, who is this other party now that's now, that's involved in this? So let me ask you, when stuff like that does happen, when you end up having a dispute in a government contract, I know it happens in the non-governmental space. Uh, I got to believe that there's probably a whole kind of special dispute resolution regime we have to comply with in the governmental space. Is that right?
Yeah, absolutely. Because when you're dealing with the federal government, you've got sovereign immunity issues. And whether that is something that actually makes any sense given our constitutional republic, I don't think so. But here we are, inherited it from the common law. So the right to sue the sovereign, the government, is totally something that can be waived by the government. And they did it here through the Tucker Act and other statutes. And they defined very narrowly what jurisdictions you'd have to go to for any of those disputes. So a dispute with the government based on contract either has to go to the boards of contract appeals, which are civilian or armed services. It's an administrative tribunal that all they handle are government contract matters. So they tend to be very good, but it has a little bit less of the formality of a court and has some slight wrinkles in their processes. Or you go to the United States Court of Federal Claims.
I see. Can you arbitrate these, or is it statutorily preempted?
Well, between the government and the contractor, we often resolve these matters through ADR, but they're non-binding. So it's typically mediation that's facilitated by the Armed Services Board or Civilian Board, or the Court of Federal Claims. Those do tend to have a really high success rate, but it's not binding arbitration. It's just you need a judge in the room sometimes to tell the parties, hey, you're being stupid, and just come to an agreement. You're just going to waste years and millions of dollars fighting this.
Non-binding arbitration, how does that work? So you get a decision by the judge, but if one party doesn't like it, they don't have to abide by it?
No, it's usually mediation.
Mediation.
Mediation's really yeah, that's the way to go.
So that's by agreement between the parties. I see. So you'll mediate the disputes by agreement. But in terms of adjudicating the dispute, uh, typically what you're saying, or sometimes the statute might require you to go to a certain court, I think is what I'm hearing.
Yeah, it's almost exclusively either these administrative bodies or the Court of Federal Claims.
Okay, okay, got it. Court of Federal Claims. Okay, and this might be an unfair question, but what's the success rate there? I mean, and I'll tell you why I ask. I mean, I just know that there's always been a little bit of skepticism or tension in tax matters. When you go to a tax court, you feel like like, first of all, you got to go through an administrative proceeding. So, the IRS determines whether, and they're a litigant and they're making a determination in appeals. Is there that sort of tension in a governmental matter, or is it like, geez, the party that's determining whether I win or not has a vested interest in this? Or has it been is that not really part of the dynamic?
That's not really part of the dynamic. I mean, people have certain opinions about the Federal Circuit and their government contracts jurisprudence on appeal, but I don't know that it's necessarily finger on the scale in favor of one side or the other. It's just feelings about how certain judges on that circuit have pushed the case law over the years. You get a fair shake. I mean, it's a court.
You get a fair shake. Okay, well, that's good to know. I guess the only downside is I know a lot of parties feel very strongly about alternative dispute, and they might not be able to access that. And then plus they might not get into court that they want to be in. That's what it sounds like.
Yeah, for the, prime sub disputes or lower tier, you can negotiate anywhere you want, right? And you might want to negotiate a place where you think they actually don't understand government contracts very well, uh, because you think that there might be some baseline rules that are better for you than the government contract variations. What I almost always see in a disputes provision between a prime and a sub is something to the effect of, we choose the law of New York shall apply, for example, or Delaware, except to the extent interpreting a provision of the federal acquisition regulation or something, analogous to that, in which case the common law of government contracts shall apply as interpreted by, the boards and court of federal claims, something like that.
Got
So
it.
that then the courts will then look, whatever jurisdiction you're in, to the body of cases that have been established on these issues.
Okay. All right. Well, so the last thing, here we are, end of December 2024. We're about to have a new administration. Everybody's making predictions about what the world's going to look like next year. How do you feel what are going to be the big events in governmental contracting? What might change? What might stay the same? Any, I guess, things to be on the lookout for?
It might not surprise you to know that I've had a lot of clients ask me that over the last month or so. Um, I don't want to pull out my crystal ball because it's cloudy, but I feel pretty confident we're going to see an easing back of any focus on environmental laws and greenhouse gas rules. We're going to see the same emphasis that we've seen actually for both of the past two administrations on domestic preference requirements. There's a lot of focus on build in America, and that sort of thing. Other than that, I mean, I do think we're going to see the administration, like it did the last time around, try to meddle directly in procurement, specific procurements in ways that are probably illegal, like they did with Amazon and the Jedi procurement. That did make some attorneys very wealthy, but I don't think it was very good for the Defense Department. I think it wasted a heck of a lot of money for no reason. I would be shocked if we don't have at least one of those types of issues pop up in the next year or two, but we'll see. It's going to be weird.
Okay. All right. Well, we'll be watching. Okay. Well, Zach, I guess the last question, if somebody wants to hear more, you're in our Washington, D.C. office, right?
I am.
Yeah. And Zachary Prince, if we can find you online, you're not hiding. With Zachary Prince, partner Haynes Boone, Washington, D.C. government contracts. This is Roger Royce with 10,000 Startups. We've been talking about government contracts. I want to thank you all for being here. Thank you, Zach. This is really interesting. It's an area of law I don't get involved in very often or run across that often, but maybe it's out there more than I think. So thanks for being with us, and we'll see you all next week.